see what it is. Do you remember who? We can get it later, but.
Judge, the jurors are present and seated.
Well, we're a little more timely today. Everybody raise your right hand, please. Do you swear or affirm to tell the truth? Okay, thank you. Please raise your hand if you got any information from any source regarding this case over the recess. Okay, I see no hands. Thank you very much. State, you may call your first witness.
Yes, Judge. The state of Florida calls Yolanda Soto.
Soto, step this way, please. Stand right here. Please raise your right hand and repeat the oath.
You do swear or affirm that testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Thank you. Step this way, have a seat for yourself up and speak in a loud, clear voice.
Whenever you're ready.
Good morning, ma'am. Could you please turn to the ladies and gentlemen of the jury, introduce yourself by stating your name?
My name is Yolanda Soto, that's S-O-T-O.
And Ms. Soto, where do you work?
I work as a crime laboratory analyst in the firearms section with the Florida Department of Law Enforcement in Tampa.
The Florida Department of Law Enforcement, does that often go by the acronym FDLE?
That's correct.
And what is FDLE?
What is FDLE?
Yes.
It is a state agency that provides technical as well as investigative services to local, state, and federal agencies.
Does your agency have a relationship with the St. Petersburg Police Department to provide those services?
Yes.
All right. You mentioned that you worked in the firearms section. What type of training and education do you have to do that?
I received a bachelor's degree in forensic science from the University of Central Florida. I was also a forensic technologist in the firearms section with FDLE in Orlando and completed a 15-month structured program specifically in firearms identification sponsored by FDLE in Tampa.
Okay. What exactly do you do in the firearms section?
As an examiner in the firearms section, I microscopically examine fired ammunition components such as fire bullets and fire casings to determine whether or not they were fired from the same firearm. I also perform distance determination examinations, serial number restorations, function tests on firearms, and input data and images into what is called the National Integrated Ballistics Information Network.
All right. Were you provided evidence in a case from the city of St. Petersburg reference to a Shannon Griffin?
Yes.
All right. And tell the jury how it is that evidence would come to you.
Evidence is received by the evidence section at FDLE in Tampa by the submitting agency. A unique FDLE number is assigned to that case, and a file is generated, and then the files are assigned to an analyst. Once they're assigned to an analyst, that analyst will retrieve the evidence from the evidence section to work.
And what type of analytical work did you do on the evidence that was submitted to you?
I received a revolver as well as 3 fired bullets, and I performed a function test on the revolver to determine whether or not it's functioning as designed, and I also examined the bullets to determine whether or not they were fired from the submitted revolver.
Have you had an opportunity to testify in court to the state of Florida previously about functionality and identification as
Yes.
relates to firearms? Approximately how many times?
Approximately anywhere from 95 to 100 times.
Okay. And as a part of your work, what percentage of your work relates to the functionality and the identification?
It's a high percentage, I would say 90% of the time.
Okay. Let's start specifically with the firearm and the functionality test. I'd like to show you what's already admitted in the state's evidence. This is State's Exhibit number 19. It's open if you need to remove it. Take a second to look at it and tell me if you recognize that item.
I do recognize the revolver by the unique FTLE case number, my initials, and the exhibit number located on the frame of the revolver.
So that's the firearm for which you did your analysis on.
Yes.
You want to pull it out so I can talk about it, just so you can set it on top of the box. Again, when you perform your analysis, that zip tie, that's not part of your analysis, correct?
No, that I put in there myself prior to repackaging and sending it back to the evidence section.
All right. You mentioned a few things about this firearm. First, you mentioned that it's a revolver.
Yes.
Okay. Explain to the jury what you mean by revolver and how that compares to other types of handguns.
Difference between a semi-automatic, for example, and a revolver is when you use a semi-automatic pistol, you use what's called a magazine or a detachable box magazine, or it's like a box-like container that's designed to hold live rounds or cartridges, and that's inserted into the pistol grip of the firearm. And when it's fired, the casings are automatically expelled from the firearm. In a revolver, the unfired rounds or cartridges are manually loaded into the chambers of the cylinder, and when fired, the casings, rather than being automatically expelled, they remain in the chamber of the cylinder.
You mentioned that it's I believe you said Smith & Wesson, is that the manufacturer?
Yes.
And there's a particular caliber or, I guess it's the caliber in this case. It was a .38 special?
It is a .38 special caliber revolver.
And what does that mean?
And that tells us what the firearm is designed to fire, what type of cartridge it is designed to fire.
Okay. And in this case, you tested it to see if this firearm was in fact functioning.
Yes.
And what did you find after performing that test?
During my testing, I found that the exhibit number 1426016 revolver was found to function properly using ammunition from our laboratory stock.
All right. And so I imagine you have a range at FDLE that allows you to test fire indoors.
Yes.
As it relates to a revolver, is it fair to say that a revolver has two types of action, a single action and a double action?
That's correct.
Can you describe for the jury what is meant by single action and double action?
With single action, the hammer has to be manually cocked first prior to pulling the trigger. In double action, pulling the trigger will cock and release the hammer.
All right. Let me, if you could, Judge, I'd ask for the witness to be allowed to step in front of the jury.
Yes, sir.
Ms. Soto, could you come here and I'd like for you to point to the jurors and show them, when we talk about the hammer, what specifically are we referring to? So in a single action, that actually manually has to be brought back before you can fire. Okay, and then how does that compare to a double action?
Double action, the trigger is pulled with the hammer in the resting position. That is now.
All right, thank you. Is there some sort of analysis that you can do as to determine what amount of pressure is required to pull the trigger when it's a single action versus a double action?
Yes, it's called a trigger pull test.
All right, and did you perform that test on this firearm?
Yes, I did.
Let's talk about the single action. What were you able to determine as to trigger pull for that firearm?
In the single action mode, the trigger pull measured approximately 3 to 3 1/4 pounds.
Okay, and that's the amount of force that's required to place on the trigger to expel a projectile?
Approximately, yes.
Okay. And as it relates to double action, what were you able to determine?
The double action trigger pull measured approximately 9 1/2 to 9 3/4 pounds.
So a little bit more pressure than in a double action, or more force, I should say, than compared to a single action.
Yes.
Based on your experience as a firearms analyst, what can you tell us about the force required? Is that within the acceptable range for that firearm?
The double action is, the single action is more on the lighter side, but it's not an unusual trigger pull.
All right, so it's not what we would consider to be a hair trigger.
That's correct.
Your Honor, I'm showing defense counsel what's been marked for identification as case exhibits 34. It's a composite exhibit, A, B, and C.
Did you say 34?
Yes, Judge.
Okay.
May I approach the witness?
Yes.
All right, Ms. Soto, I'm going to ask you to look at case exhibit 34, it's a composite exhibit. A, B, and C. Take a second look at the packaging. Let me know when you had an opportunity to look at it and identify them.
Yes, I recognize the packaging by the unique FDLE case number, my initials, and the case numbers.
All right, and what is contained in those packages?
Each one contains one fired .38 caliber class bullet.
All right. Let's take a second to kind of step back a little bit as it relates to bullets and shell casings. Which
Do you want to get somebody up here to look at it?
in a minute, Judge. I think we're okay for
All right.
deliberation.
Okay.
Ms. Soto, I'm going to show you what's previously introduced as State's Exhibit 11B. You recognize what's being displayed here in this photograph?
Yes, I do.
Okay, this is the revolver with the shell casings inside the cylinder for which you've described.
Based on what I'm looking at, I can only see the base of the cartridges, so I'm not sure if they're unfired or fired.
Okay.
But there are at least 6 loaded in the chamber of the cylinder.
All right. Ms. Dodge, forward to the jury. Ms. Soto, there's a difference between a casing and a projectile, correct?
That's correct.
All right, and describe what that difference is so the jury kind of understands.
Before a live round or a cartridge is fired, it's one unit. It contains the powder inside the casing, it contains the ignition component located at the base of the cartridge, and it contains the bullet. When a cartridge is fired in a firearm, the cartridge case in a revolver will remain in the chamber of the cylinder, and the bullet is the part of the cartridge that travels down the barrel of the firearm, out the end of the barrel, and towards the object.
Okay. As the bullet travels out the end of the gun, are marks left on the bullet as it travels through the barrel?
Yes.
All right. Tell us a little bit how that happens and why that happens.
As a bullet travels down the barrel of the firearm, it picks up unique markings from the inside of the barrel. That's the signature of the firearm. Those are the characteristics that are examined when attempting to determine whether or not a specific firearm was used. There are other markings that are imparted onto the surface of a bullet. It's called rifling impressions. Rifling is done in the manufacturing process, and it typically involves cutting grooves into the barrel of the firearm with a spiral twist, either with a right twist or a left twist. And this is done to impart a spin to the bullet. It stabilizes the bullet, so as it leaves the barrel of the firearm, it improves the accuracy as well as the range of the bullet. For example, if a manufacturer chooses to cut 5 grooves into the barrel of a firearm with a right twist, and bullets fired from that barrel will display 5 impressions of those grooves, also with a right twist.
So there are certain markings on a bullet that are put there by design by the manufacturer, and then some that may be unique or specific just based on wear or use of a firearm, correct?
Right.
All right. And when you're doing your analysis, are you looking for both the, I guess, the manufacturer marks and any unique marks to the firearm itself?
Yes, the manufacturer marks are called class characteristics, and the class characteristics must agree, those are measurable features, and they must agree before comparing the unique identifying characteristics on the bullet to determine if they were fired from a specific firearm.
And in this case, you already told the jury that you did a test fire, and you were able to use that bullet from the test fire for the purposes of comparison to maybe unknown bullets.
Yes, I used the submitted revolver and test fired it using ammunition from our laboratory stock, recover the bullets from our water tank in the range, and then microscopically compare the markings on those test fire bullets to the individual markings on the bullets that were submitted in this case.
Right. Judge, at this time, the state would seek to admit State's Exhibits 34, the composite exhibit 34A, B, and C, if I haven't already.
Any objection?
No objection.
That's admitted. Thank you.
All right, Ms. Soto, let's talk about the projectiles that were provided to you, or the bullets, excuse me, and the analysis that you performed on it, and ultimately what your opinion was, okay? Let's start, let me take them over here. Again, when an item comes into FDLE, it has an agency number, and FDLE gives it an FDLE number too, correct?
That's correct.
So let's talk about the item that was mentioned as the FDLE number 1427366. That's marked as state FDLE item number 2. Were you able to determine whether or not this had any identifying features specific to that firearm?
The bullet did display class characteristics, 5 grooves or 5 impressions, similar to test fires or the same as the test fires that were recovered using the revolver. But they did not display meaningful agreement or disagreement of identifying characteristics. Therefore, I reached an inconclusive result.
All right, so this bullet had the same class characteristics as something that would come from that firearm, but it lacked the specific detail to make an identification.
That's correct. The bullet displayed 5 grooves with the right twist, and test fires recovered using the submitted firearm also displayed 5 grooves with the right twist.
Okay. Let's talk about the agency number that was provided to you, 142768, and I guess that was given the FDLE number 3. Were you able to compare this to the known from that firearm?
Yes, I compared the unique identifying characteristics on that exhibit to test fire bullets recovered using the submitted revolver and concluded that this exhibit was fired from the submitted revolver.
So this bullet contained both the class characteristics and the unique specific characteristics to that firearm?
Yes.
All right. And finally, the agency number 1427369. Again, this is agency number 4. Again, the same analysis you performed on this item as to the others?
Yes.
And what were you able to determine about this projectile?
I was also able to identify this bullet as having been fired from the submitted revolver.
Again, same class characteristics as well as additional individual characteristics?
Yes.
Okay. May I have a moment, Your Honor?
Yes.
No further questions of this witness, Your Honor.
Thank you. Cross-examination.
Thank you, Your Honor.
You're welcome.
Good morning, Ms. Soto.
Good morning.
What is it about a 38 special model that is unique to that model? Why is it called a special?
The caliber designation of that revolver.
Would all 38s be considered 38 specials?
No, there are different types of 38s, such as 38 long or 38 short, but 38 special is not the only caliber.
Okay. Does it take a specific type ammunition that only works in the 38 Special?
It would be recommended that what's stamped on the firearm is what should be used.
And is that what happened in this case? Did your analysis show, when comparing the bullets that were retrieved from the crime scene, were those 38 Special type ammunition?
Those bullets were found to be 38 caliber class bullets and were identified to, or two of them were identified to the revolver.
All right. And what was the length of the barrel of this particular gun?
I did not measure the length of the barrel.
But it is a common type pistol, correct?
It's a revolver.
Okay. And you had talked earlier during direct examination about trigger pressures and had mentioned that on a single action firing, 3.25 pounds, I believe, and on a double action, 9.5 to 9.75, in that range?
Yeah.
Is that correct? Now, my question is, do you know if it was utilized in a single action fashion, or was it utilized in a double action fashion during the crime that's alleged in this case?
No, I did not.
If it was in double action use, 9 pounds, slightly more than 9 pounds, that sounds like that would be a significant amount of force required to pull the trigger on it. Is that fair?
It's heavier, obviously, than 3.5.
And the gun itself also would normally have a serial number, correct?
Yes.
And this gun had a serial number, correct?
Yes.
And there have been no attempts to eradicate that or conceal that serial number, correct?
No.
With that serial number, what's the purpose of the serial number on a firearm?
It's stamped by the manufacturer.
And what use is it of to law enforcement?
I believe it's just during the manufacturing process. Each one is given a unique serial number.
Wouldn't that mean that that gun would then be traceable to the purchaser of the firearm?
It can be, yes.
Do you know if, in this case, was there any attempt to trace the ownership of the firearm?
I don't know. But may I say one thing about the serial number? My understanding is that it should be a number that's unique to that firearm, but I can't say for certain that there can't be two firearms out there with the same number.
If I understand you correctly, you believe that more than one gun may share the same serial number?
It's supposed to be, my understanding, unique to one firearm, but could there have been a mistake in the manufacturing process? I have no idea of knowing that for certain.
Have you personally ever run across that situation?
No, I haven't.
Have you ever read about it in any of your journals?
May have heard about it, or I believe I have during training 13 years ago, but I don't recall the specifics.
Now, when you're testing a weapon to see if it's functional, you're checking basically all aspects, single action, double action, making sure that it's working in the manner that the manufacturer designed it to work, correct?
Right.
And in this case, I believe I heard you testify that this one was fully functional to your knowledge?
It was found to function properly during my testing, yes.
Now, I noticed in your report, you had mentioned that the revolver's incorporated safety mechanisms were also operating as designed at the time of testing. What would those consist of, the safety mechanisms?
May I refer to my note?
Oh, certainly.
It is a rebound slide and a hammer block.
And explain that to the jury.
And those are safeties that keeps the hammer away from the firing pin unless the trigger is pulled back completely. And the firing pin is that part of the firearm that comes in direct contact with the base of the live round, causing the ignition.
Now, this particular type weapon being fully operational based upon your testing, would that be a difficult type weapon to accidentally discharge or misfire?
In my opinion, I would say yes.
That someone would have to, with the forces that you've already described, intentionally pull that trigger, simply dropping it on the ground or tussling with someone. Doesn't sound like it would be enough force unless there was a finger on the trigger pulling it.
In my opinion, I don't expect this firearm to accidentally discharge, and it would discharge if you pull the trigger completely rearward. Due to the safeties, and even if it was dropped, I don't believe that it would generate enough force, that fall would generate enough force to cause a cartridge to discharge.
And in this case, all 6 bullets were discharged, were fired, correct?
I received 3.
Okay.
bullets.
Were you given any background information on how many had actually been discharged from the gun?
No.
All right. Would you agree that the more shots fired, the percentage of this being some type of accident or tussle diminishes considerably if there's a second, third, fourth, fifth, and 6th shot, correct?
Are you asking whether or not it would have a greater chance of discharging?
No, no, I'm saying it would be less, even more less likely to have been the result of some accident during a struggle if all 6 shots were fired from the gun, correct?
I'm not sure I understand your question.
Well, what I'm getting at is you already indicated in your expert opinion that you didn't believe that an accidental discharge would be something that would be probable or even possible in this case.
That's correct.
Now, I'm saying add on more shots and an even less probability. If somebody shoots at somebody 6 times, sets the gun down.
Okay, do you want to approach the bench?
Yes, Judge.
Thank you.
Is there any way, based upon your examination of the firearm and the bullets, in this case, I believe you were provided casings in addition to bullet fragments, or?
I was just provided the 3 fire bullets, no case.
Okay. Is there any way to tell the age of the firearm or the age of the ammunition?
If there is, it's not something that I perform. It's not a test that I perform, and I don't believe that there is.
Okay. And let's see. I may have a moment, Your Honor.
Yes, sir.
No further questions, Your Honor. Thank you.
You're welcome. Mr. Labruzzo?
Ms. Soto, you were asked some questions about the traceability of firearms based on their serial number. Are you familiar enough with gun laws enough to say that each state has different gun laws?
I am not as familiar with the serial numbers.
Okay.
My specialty I am firearms examiner, and I specifically deal with identifying components or attempting to back to a specific firearm.
Let me ask you this question. This is your area of specialty. Do you have a database that contains all the serial numbers for every firearm in the United States?
The firearm section does not.
Okay. And as it relates to the trigger pull of the firearm, did you have any difficulty in firing that gun?
I did not.
Did you fire it in both a single and double action?
Yes, I did.
And you had no difficulty doing it yourself?
No, I did not.
Okay.
Is she excused?
Yes, Judge.
No objection.
All right, you're free to go, ma'am.
Thank you.
You're welcome. Next witness, please.
Box that's on the stand.
The state would call Janelle Voorhees.
Get everything back?
You do swear or affirm that testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
So this way have a seat on yourself up and speak in a line of the
Whenever you're ready.
Thank you, Judge. Good morning.
Good morning.
Could you please state your name for the record?
My name is Janelle Voorhees, Borries.
And
And
speak up
Miss-
just a little bit, okay, ma'am? Thank
Yes,
you.
ma'am.
You can lift that up if you need to.
Okay.
Okay. Where are you employed, Ms. Voorhees?
I am employed by the Pinellas County Forensic Laboratory as an assistant laboratory director supervising the DNA section.
And in that section, what are your duties specifically?
My primary duty would be the supervision of the unit. However, I am a full-time caseworking analyst as well. The amount of casework I do is directly proportional to how much casework is submitted to the laboratory.
And how long have you been employed there?
With Pinellas County, approximately 4 years now.
Have you had other experience prior to working for Pinellas County?
Yes, I have. I was a DNA analyst with the Florida Department of Law Enforcement in the biology DNA section for a little over 11 years.
And what sort of education do you have to become this specialist?
I have a bachelor's degree from Florida State University in biology with emphasis in molecular and cellular biology. I also have graduate coursework from the University of South Florida in biostatistics and biochemistry.
And could you please tell the jurors what forensic serology is?
Forensic serology is the attempt to identify body fluids on items of evidence, blood, semen, or saliva.
And what is forensic DNA analysis?
Forensic DNA analysis is the attempt to develop a unique DNA profile from items of evidence that can then be used for comparison purposes.
Have you ever received any specialized training in forensic serology or DNA?
Yes, I have. Obviously, with the Florida Department of Law Enforcement, I completed their training program as part of a continuing education program. While I was working as a caseworking analyst there, I attended numerous conferences or seminars or workshops dealing with forensic serology, forensic DNA analysis, and the applicable statistics.
And I'm sorry, go ahead.
When I moved over to Pinellas County Forensic Laboratory, I completed a modified training program, their analyst training program. It was modified because I had obviously been trained, and also have continued on that continuing education program since I've been there, attending more conferences, workshops, and seminars dealing with forensic serology, forensic DNA, and the statistics.
Have you ever taken any proficiency tests in forensic DNA?
I have successfully completed at minimum 2 proficiency tests every single year since I was a qualified DNA analyst.
Is your laboratory accredited?
Yes, it is.
And could you please tell the jurors what that means?
Laboratory accreditation is when an outside accrediting body, in our case, it's ASCLD Lab, which stands for American Society of Crime Laboratory Directors Laboratory Accreditation Board. And what they do is they send in a team of assessors and they evaluate your laboratory against a set of standards. These standards cover everything from your management structure, qualifications of the individuals, security, all the way down to they make sure you are following your own policies and procedures. Once you meet or exceed these requirements, you obtain your accreditation. In order to maintain that accreditation, that accrediting body, ASCLD Lab, will come in every 5 years and assess your laboratory again.
And what was the body, the accreditation body that,
ASCLD Lab.
okay. And when did Pinellas County receive such accreditation?
The laboratory itself received its accreditation in 1988. However, the DNA section is the newest section, and we received our accreditation in December of 2009.
And you will have another test, so to speak, 5 years from that time?
In December of this year.
Okay. Could you please tell the jurors what DNA is?
DNA stands for deoxyribonucleic acid. The best way to think about DNA is it's a genetic blueprint. You get half your DNA from your mom and half your DNA from your dad. Over 99% of our DNA is exactly the same, but there is that less than 1% that's unique and gives us our individual characteristics. It's a portion of this less than 1% that I analyze in an attempt to develop a unique profile.
And where is DNA found in the human body?
DNA is found within the nucleus of any cell, sperm, blood, skin cells, any cell within the body with the exception of mature red blood cells.
And could you please explain the STR method of testing to the jurors?
Well, what STR stands for is short tandem repeats. And what these are is regions of the DNA that everybody has. But how we differ from one another is the number of these repeat units, or the length. So the instrumentation that I use allows me to measure those lengths. The instrumentation will generate results, and I will then interpret those results and make any comparisons that may need to be made. The STR process is essentially a 4-step process. The first step is called extraction. We have got to liberate the DNA, the cells, from whatever it's on, whether it be a swab or a t-shirt or whatever the substrate is, and then we need to liberate that DNA from inside that nucleus. So that all happens during the extraction step. The next step is called quantitation. And in this step, we're trying to determine how much DNA do we have. Do we have a lot? Do we have a little? We need to know for the next step how much DNA we have. The next step is called amplification. And this is the step in which we make millions of copies of just those locations that I'm looking at. The final step is the typing step, and that is where the profile, the results are developed, and then I come after that step and interpret that data.
And what type of DNA analysis do you usually perform?
The STR method that I just spoke of.
Did you have occasion to examine some items of evidence in the case involving State of Florida versus Jennifer Mee?
Yes, I did.
If I could approach.
Yes.
I'm showing you what's been marked as entered into evidence as State's Exhibit 18.
Okay.
Can you tell me if you had an opportunity to look at that as part of your examination in this case?
Yes, I did.
And how do you know that?
It has the Pinellas County Forensic Lab tracking number, the case number, as well as my handwritten initials, date, the case number, and the item number. Also, it was previously sealed, and my initials and date are on that seal.
And is there something on that that tells you what that item is in the bag?
Yes, the St. Pete Police Department's evidence label often indicates what is in the package.
And what is in that specific?
A black baseball cap, EM number 7.
Okay. I'm showing you what's been entered into evidence as State's Exhibit 16. Again, the same question. Did you have an opportunity to look at that?
Yes, I did.
And could you please tell the jurors what that is?
It is represented as being a left Jordan slide from EM number 1.
And again, the same markings are on there that show you that you actually looked at this item.
Yes, ma'am.
I'm showing you what's been entered into evidence previously as State's Exhibit 17. Have you had an opportunity to see that in the past?
Yes, I have.
And your markings are on that bag as well?
Yes, ma'am.
And what does that bag contain?
This is represented as being a right Jordan slider from EM2.
I'm showing you what's been entered into evidence at State's Exhibit 24. Did you have an opportunity to examine that piece of evidence?
Yes, I did.
And how do you know that?
It has all of those markings that we previously discussed.
Okay, and what is that? What is the evidence that's inside that bag?
It's represented as a white tank top and a blue bag.
And I'm showing you what's been introduced into evidence as State's Exhibit 30. Did you have an opportunity to look at that?
Yes, I did.
And what was in that bag?
It was represented as a red T-shirt from floor in bathroom of 589th Avenue North, number 7.
And I am showing you what's been entered into evidence as State's Exhibit 21.
Okay.
Did you have an opportunity to examine the items in that envelope?
Yes, I did.
And what are those items?
They were represented as swabs from shell casings in gun.
And I am showing you what's been entered into evidence at State's Exhibit 20. Did you have an opportunity to examine that piece of evidence?
Yes, I did.
And could you please tell the jurors what that piece of evidence is?
Is a condom wrapper, EM3, and then there's a 9. Not sure.
Okay. And I am showing you what's been entered into evidence as State's Exhibit 22.
Okay.
Did you have an opportunity to examine that?
Yes, I did.
And what are those items?
They are swabs that are represented as being from the hammer of the gun, the trigger of the gun, and the grips of the gun.
Was that 21 and 22? You have it over there. Thank you.
I thought there was 21 and 22 also, but I could be wrong.
I'm also showing you what's been entered into evidence as State's Exhibit 23A, 23B, and 23C. Did you have an opportunity to look at that item?
Yes, I did.
Okay, and what, could you please tell the jurors what that is?
They are represented as oral or buccal swabs from Rayford, Me, and Newton.
So some of these items are actual pieces of clothing or shoes, and some are swabs.
That's correct.
Could you tell the jurors how and why and what the difference is in your examination of these items?
The items that came in as actual items, for example, the tank top, the red shirt, the slides, those came into the laboratory and I personally swabbed them, took those swabbings and carried those swabbings through the DNA process. With the items like, for example, from the gun or the shell casings, that the agency physically swabbed those items and just submitted to me the swabs. At that point, all I need to do is take a cutting or a portion of those swabs and carry that portion through the DNA process.
And also the swabs that are represented to be from me, Newton, and Rayford. How do you get these swabs?
Those are submitted by law enforcement. They're represented as being known or reference samples from those individuals.
And exactly what is on the envelope that you're looking at? Do you?
They look like a long one-sided Q-tip. It's just if you picture one half of a Q-tip but with a longer stick. They're sterile. If you've ever had like a strep test, the doctor breaks out, they're that, and they simply ask the individual to vigorously rub the inside of their cheek, and that gives me ample skin cells to typically develop a profile.
And on all the items that I have just shown you, did you have an opportunity to conduct tests on all these items?
Yes, I did.
And what type of testing did you conduct?
STR testing.
That's the DNA testing you earlier told the jurors about?
Yes, that's correct.
Let's talk a little bit about your laboratory and how you prevent contamination.
Okay. First of all, contamination for our purposes is the introduction of DNA into a sample or an item of evidence. We take many steps to not only prevent but detect contamination should it occur in the laboratory. One of the key things that we use is what we call personal protective equipment, or PPE. We're going to have on a lab coat, gloves, and a mask pretty much any time you're back in the DNA laboratory, regardless whether you're working on evidence or not, but especially if you're working on items of evidence. You're going to have a clean, clutter-free work area. And a key component to that equation is that you're only going to have one item of evidence open at any given time, whether it be one item of evidence or one tube, only one thing at a time. We also have distinct areas in the laboratory for the cutting or the serology, that first where I'm looking at those body fluids, that's a distinct area in the laboratory. That extraction step has a distinct place in the laboratory. The amplification has a distinct, so it's segregated in the laboratory. It's a one-way flow. It doesn't go backwards. All the cases move only forward. Another key component is that our questions and our known samples are separated. They're separated by date and or time. So if you've worked the knowns or the questions from one case in one particular area, you have to move to a whole different area or come back on a different day to work those known samples. Also in the extraction part, we introduce a blank or a control. It's called a reagent blank. And what that does is it ensures that the chemicals that we use have not had any kind of contamination event. It also checks my technique. If there's been any carryover or anything, that sample will most likely detect it. Next, in the amplification stage, we introduce what's called a negative control. Again, this is serving to let me know, make sure all of those chemicals are clean and contaminant-free, and it also checks my technique. Both that reagent blank and that negative control are carried all the way through the DNA process in an attempt to detect and alert me if there's any type of contamination event. Also, we have staff databases. We maintain a staff database that can be searched. Any profile can be searched to ensure that it is not staffed.
And did you use these safety techniques when you examined these items of evidence?
Yes, I did.
I have a few more things that we need to go through prior to us actually getting into what you found. Have you ever had any specialized training or classes in statistics?
Yes, I have.
And could you please tell the jurors what that is?
As part of my undergraduate, I had classes that dealt with population statistics specifically. Of course, I had the module at the Florida Department of Law Enforcement. I also had the graduate course in biostatistics at the University of South Florida. I've attended a week-long statistical workshop put on by Dr. Dr. George Carmody, who was a renowned geneticist and statistician. He came into our laboratory, and you had to get your certificate that you completed it. You had to pass the test. And then as part of that continuing education program, almost every conference there is a talk or a workshop dealing with the statistics that we routinely calculate. And of course, at Pinellas County Forensic Lab, there's also a statistical module that I successfully completed in that training program as well.
And in this training, do you learn about a database?
Yes, we do.
And could you please tell the jurors what a database is?
For my purposes, a database is a collection of DNA profiles that has been statistically shown to represent the population as a whole.
And how is this information collected for the database?
The database is, the samples are what are referred to as convenience samples, meaning they're easy to come by. They're law enforcement, laboratory personnel, family of laboratory personnel, et cetera.
How is the racial makeup of the donor determined?
The racial makeup is typically self-proclaimed. If the person didn't fill it out, then the person drawing the blood would make that determination.
And which database is used by the Pinellas County Forensic Lab to determine statistical frequencies?
The FBI database.
Has this database been published?
Yes, it has.
And has it been peer-reviewed?
Yes, it has.
How were the samples obtained in the database?
The samples were all obtained by Dr. Arthur Eisenberg at the University of North Texas.
And how is it determined if a particular database is suitable for statistical analysis of how frequently the combination of certain alleles will occur to a given population group?
The database is reviewed by statisticians and geneticists, and they're looking for three main things. First is what we expect, actually what we observed. They're making sure that there's no two of the areas that you're looking at are linked in any way. They need to be random events, and then that there are no duplications in that database. And once those three criteria are met, it is statistically sound.
Once you have identified that specific loci in a given sample, are you able to place a statistical significance to the frequency that such a combination will occur within a given population?
Yes, once I have a DNA profile at each location or loci, I can then take each individual DNA type, because now that database lets me know how often each one of those DNA types occurs. And so if I simply put those two DNA types together, I can, in basic terms, multiply those two frequencies together to determine the frequency of that location as a whole.
And what is the Hardy-Weinberg equilibrium?
The Hardy-Weinberg equilibrium is a pretty basic genetic principle that states if a population is in or approaching Hardy-Weinberg, the population is in a steady state as it pertains to population genetic variation. And that's a lot of words, and this is what it really means. It states that the genetic frequencies remain constant. So if we assume that our population's approaching Hardy-Weinberg, which it is, the genetic variation stays the same. And why that's important is because that's why I don't have to have the DNA profiles from everybody who's ever lived or ever will live or lives now, because the genetic variation, how frequently those types occur, is constant. So it doesn't matter who lived 100 years ago or who's going to live 100 years from now, because those genotypes, and when I say genotype, I mean DNA type. That particular DNA type, is how often it occurs, is constant from generation to generation, and that's why it's important to what I do.
And could you explain the product rule to the jurors and how you utilize that?
The product rule is a statistical principle that allows you to determine how often a number of random events will occur simultaneously. For example, for me, each location is an independent event. So in order for me to determine how often all 15 of those independent events occur at the same time, I simply take how often the first one, multiply it by the second one, and so forth. And so what that allows you to do is get that frequency of occurrence of the profile as a whole.
And could you tell the jurors what SWGDAM is?
SWGDAM stands for Scientific Working Groups on DNA Analysis and Methods. And what this is a body that's made up of all FBI mandated, and it's made up of statisticians, forensic biologists, experts in the DNA field. And what they do is they set forth recommendations, whether it be on how much education I have to have, how much training I have to have, even all the way down to recommendations as far as interpretation. but they are really a body of experts that lends guidance to the forensic DNA community.
And what about NRC2?
NRC2 is actually a publication. It was published in 1996. And what this publication did, it's National Research Council is what NRC stands for. It was a group of experts that made recommendations specifically dealing with the statistics that I do. And most laboratories follow those recommendations as well as mine does.
And did you perform statistical analysis on all the items of evidence that you looked at and examined?
I don't know if I did it on all of them, but any of them that needed that statistical weight provided, it was calculated, yes.
And now that we've gone through all those preliminary questions, let's get down to the meat of what you did in this particular case. And I'll start with, I'll use your numbers, items 1A, which was the swabs of the hammer of the gun.
That's correct.
Did you examine that?
Yes, I did.
And did you make any comparisons in that examination?
Yes, I did.
And could you please tell the jurors what you determined?
I did DNA analysis on that item. Resulted in a mixture of at least 2 individuals. And when I say mixture, what I mean is there's more than one person's DNA types represented. This was at least 2 individuals. The profile of the major contributor could be determined. And when I say the word major, another way to think of that, it would be the predominant profile, the person whose DNA was there in the highest concentration. And that major profile was consistent with the buccal swabs from LaRon Rayford. Once that match or that consistency was noted, the appropriate statistical weight was then applied. The probability of selecting an unrelated random individual who could be a contributor to that major profile is 1 in 1.7 billion in the African American population, 1 in 250 billion in the Caucasian population, and 1 in 330 billion in the Hispanic population, and that is based on 9 out of the 15 locations that I look at. Further comparisons were made because it was in fact a mixture, and it was determined that no determinations can be made regarding the contribution of the buccal swabs from Jennifer Mee or the buccal swabs from Lamont Newton. And what no determinations means is simply that there was not enough definitive information in that mixture to say whether that person or those people were there or were not there. Another way to think of it would be inconclusive. There's not enough information to support an inclusion or an exclusion regarding those individuals.
So you know that there was someone else that had contact with that item,
There was other DNA types detected, that's correct.
but not enough for you to test. Is that correct?
There
Or-
wasn't enough information in that mixture to definitively include or exclude those 2 individuals.
Okay.
I, for example, am excluded, but there wasn't enough information to include or exclude those specific individuals.
Okay, thank you. Let's move to item 2A, which I believe are swabs of the casing swabs.
That's correct.
And could you please tell the jurors what your testing results were?
Those DNA analysis results are consistent with the buccal swabs from LaRon Rayford. Again, the statistics were applied. The probability of selecting an unrelated random individual who could be a contributor is 1 in 7 in the African American population, 1 in 23 in the Caucasian population, and 1 in 18 in the Hispanic population. Those statistical calculations are only based on 1 of the 15 areas that I examined.
In that selection, where there was only one contributor that you found on those,
That's correct.
so we didn't have a major and a minor.
No, ma'am.
And I believe another casing swab was item 2B.
That's correct.
Could you please tell the jurors about your testing of that swab?
The DNA testing results from 2B are consistent or match the buccal swabs from LaRon Rayford. Excluding an identical twin, the source of the DNA in item 11A, which is the buccal swabs from LaRon Rayford, is the source of the DNA in item 2B to a reasonable degree of scientific certainty. Again, the statistics were applied. The probability of selecting an unrelated random individual who could be a contributor is 1 in 310 quadrillion in the African American population, 1 in 55 quintillion in the Caucasian population, and 1 in 95 quintillion in the Hispanic population. This is based on 15 out of 15 of the locations that I look at.
And the next item in your report is a baseball cap that you examined.
That's correct.
And could you please tell the jurors what you found there?
Item 5 is the baseball cap represented as being from the scene. It was a mixture of at least 3 individuals. The profile for the major contributor could be determined. The major is consistent with the buccal swabs from LaRon Rayford. Again, you have the excluding the identical twin. The source of the buccal swabs, which is LaRon Rayford, is the source of the major DNA profile in item 5 to a reasonable degree of scientific certainty. Again, the statistics were done. There, the probability of selecting an unrelated random individual would be 1 in 10 trillion in the African American population, 1 in 2.8 quadrillion in the Caucasian population, and 1 in 830 trillion in the Hispanic population. These statistical calculations were based on 12 of 15 locations. The other comparisons were made. The source of the buccal swabs from Jennifer Mee and the source of the buccal swabs from Lamont Newton cannot be excluded as a possible contributor. And what cannot be excluded, it means, is that it was that their DNA types were present, or there was a reasonable explanation why they would not be, scientific reasoning. We also provide statistical weight for that type of interpretation. The probability of selecting an unrelated random individual who could be a contributor to the mixture is 1 in 2 in the African American population, 1 in 2 in the Hispanic population. This is based on 1 of the 15 locations that I look at. So what is done, this statistic is calculated differently than the statistics that I've previously spoken of. What this statistic does is it takes, I had a mixture, right? It was at least 3 individuals. So what we have to do is we have to consider every single possibility of all the different DNA types that are in that particular mixture. And so the math is a little different, but it's the most conservative thing to do because you don't know, you're making no assumptions. So you're calculating how often all of those individual DNA types would occur individuals. So the math is the same concept, but calculated a little different.
Item 6 in your report is a tank top. Did you have an opportunity to examine the tank top?
Yes, I did.
And I believe that I showed you that piece of evidence, all these items, in fact.
Yes, ma'am.
Please tell the jurors what you found.
Item 6, the tank top resulted in a mixture of at least 3 individuals. The major profile could be determined. The major profile is consistent with the buccal swabs from Jennifer Mee. Excluding an identical twin, the source of the DNA in the buccal swabs from Jennifer Mee is the source of the major DNA profile in item 6 to a reasonable degree of scientific certainty. The statistics, the probability of selecting an unrelated random individual who could be a contributor of that major profile is 1 in 1.9 quintillion in the African American population, 1 in 16 quadrillion in the Caucasian population, and 1 in 360 quadrillion in the Hispanic population. This is based on 13 of 15 of the locations that I look at. The profile of one of the minor, because remember it's at least 3, so of one of the minor contributors could be determined and is consistent with the buccal swabs from Lamont Newton. Excluding an identical twin, the source of the buccal swabs from Lamont Newton is the source of one of the minor DNA profiles to a reasonable degree of scientific certainty. The probability of selecting an unrelated random individual could be one of the minor profiles is 1 in 7 trillion in the African American population, 1 in 3.3 trillion in the Caucasian population, and 1 in 1.0 trillion in the Hispanic population. That is based on 10 of the 15 locations. The buccal swab, the source of the buccal swabs from LaRon Rayford is excluded as a possible contributor to that mixture.
Item 7A on your report appears to be an area from the front of a T-shirt.
That's correct.
And could you please tell the jurors what your testing results were?
The DNA analysis, center lower area of the front side of the shirt, that was a mixture of at least 4 individuals. However, the major profile could still be determined, and it is consistent with the buccal swabs from LaRon Rayford. The probability of selecting an unrelated random individual who could be the major profile is approximately 1 in 320 billion in the African American, 1 in 2 trillion in the Caucasian population, and 1 in 9.4 trillion in the Hispanic population. And that is based on 11 out of the 15 locations. The source of the buccal swabs from Jennifer Mee and the source of the buccal swabs from Lamont Newton cannot be excluded as possible contributors. So it's that same statement that we previously talked about. The probability of selecting an unrelated random individual who could be a contributor to the mixture is 1 in 117 in the African American population, 1 in 77 in the Caucasian population, and 1 in 58 in the Hispanic population. Those statistical calculations are based on 7 of the 15 locations. The source of the stain card from Shanandre Griffin is excluded as a possible contributor to that mixture.
And that's item 7A.
Yes, ma'am.
And in your report, you have marked item 7A as the source being a T-shirt from the bathroom floor.
Well, 7 was marked as the bathroom floor, but because this is an area specific to only the T-shirt, my report says center lower area front of T-shirt.
That's 7A. That's what we've just discussed.
Yes, ma'am.
And 7C is another area of that same T-shirt.
Right. That area is what we call wear area, and what we mean by wear area is simply exactly how it sounds. The collar, the armpit, any area of something that comes into routine contact by simply wearing an item, we can swab those areas and very often detect a DNA profile, usually a mixture, but a profile.
And how about item 7C? What were your results?
That wear area was a mixture of at least 3 individuals. The major could be determined and is consistent with the buccal swabs from LaRon Rayford. Excluding an identical twin, the source of the buccal swabs from LaRon Rayford is the source of the major DNA profile to a reasonable degree of scientific certainty. The probability of selecting an unrelated random individual who could be that major profile is approximately 1 in 310 quadrillion in the African American population, 1 in 55 quintillion in the Caucasian population, 1 in 95 quintillion in the Hispanic population. And that is based on 15 of 15 locations. No determinations can be made regarding the contribution of the source of the buccal swabs from Jennifer Mee or the source of the buccal swabs from Lamont Newton to the mixture. Again, like we discussed with the no determinations, there wasn't enough definitive information to make an inclusion or an exclusion.
And I think I might have stopped you at 7A before you got to that. You could not make a determination of the minor contributors of this center of the T-shirt either.
Right, the minor contributors, the profiles of the minor contributors could not be conclusively determined. Where, if you remember back, there was a few items ago that I was able to determine the major and one of the minors. Well, in both of 7A and 7C, a profile for that minor could not be conclusively determined.
And your item 12, a condom wrapper. that you identified earlier that's in evidence. Could you please tell the jurors what you determined on that test?
That was a mixture of at least 2 individuals. The major could be determined, and the major profile was consistent with or matched the buccal swabs from LaRon Rayford. The minor contributor could not be conclusively determined, and the probability of selecting an unrelated random individual who could be a contributor is approximately 1 in 1.5 million in the African American population, 1 in 41 million in the Caucasian population, and 1 in 21 million in the Hispanic population. And that is based on 5 of 15 locations.
And Ms. Voorhees, were there any other items that you tested in this particular case? Were you given anything else that you performed any testing on?
Yes, I was.
What was that item?
Well, I only talked about the swabbings from the casings.
Uh-huh.
Only, let's get to that. We only talked about 2A and 2B, I think,
Okay.
which is all I have them as swabs from a casing. I don't know where the casings were or anything like that. So my numbers are by which random.
So we have other casings that you...
Yes, ma'am.
Yes, please go through that.
2C did not result in a definitive DNA profile, and what that means is that there were results, but there weren't enough to compare. They were insufficient for comparison purposes. 2D, the same thing, did not result in a definitive profile. 2E did not yield results at all. There was no profile obtained. And 2F was not a definitive profile.
I think you also examined, you have it as item 3, a left shoe slide,
That's correct.
and the results of that?
Did not yield a DNA profile. And then I did also the right slide shoe, and that was not a definitive profile as well. The bulk. I also did just the serological examination on jean shorts and a polo shirt that were represented as being from LaRon Rayford.
Mm-hmm.
Both of those were negative. They failed to indicate the possible presence of blood, and so no DNA was carried forward on them because there was no biological fluid identified. And that's everything.
And Ms. Voorhees, have you testified in the courts before in DNA analysis and statistical testing
Many times,
here in Pinellas County?
yes.
If I could have a moment, Your Honor.
Yes, ma'am.
Ms. Voorhees, are there things that can destroy DNA on items?
Absolutely.
And can you think of anything in particular that could do that?
I know that bleach will do it. Heat, extreme heat will do it. Dirt, DNA does not like dirt. Washing and drying can greatly diminish my ability to get a profile, but I would think that one of the most common things, and what we even use in the laboratory, is bleach.
And do you use bleach to clean your...
The surfaces, or some of the surfaces, not all of them, but the ones that where contamination is most likely, bleach can be used, yes.
Okay, cross-examination?
Thank you, Your Honor. Good morning, Ms. Voorhees.
Good morning.
Ms. Voorhees, I just want to take a few moments to kind of explain to the jury how it is that DNA can be left behind on whatever item or object that's being examined, if that's okay.
Okay.
All right. For example, you're familiar with the term shedding.
Yes, I am.
Okay. And for purposes of educating the jury, if there are different types of shedders, isn't that true?
That's correct.
In other words, some people may shed more than other people.
Yes, they do.
All right. For example, if I'm a profuse sweater, if I sweat a lot on my hands, like they are now, for example, sweat would increase the amount of dead skin cells through my pores. Is that correct?
It could. It doesn't
Okay.
have to, but it often facilitates the transfer of skin cells, yes.
All right. So if I sweat a lot, then I'm potentially shedding a lot.
Potentially, yes.
All right. And the more I shed, the more likely whatever object I touch, it's going to leave behind DNA, correct?
It's going to leave.
There's the people who shed more than others, and we've already described that. Now, in terms of other items can also leave behind DNA. For example, if I were to stick my finger in my nose, mucus could leave behind DNA.
Yes, it would.
All right. Another reason why a person may shed more than others is if hygiene can come into play,
Yes,
or the lack of hygiene.
yes.
All right. So if I'm a person who never washes my hands, I'm more likely to leave behind DNA. Or I'm a
Typically,
Typically,
you're more
okay.
likely to leave behind.
All right. Now, with that being said, you mentioned some of the items that you've tested, and we'll go to that in a minute, but based on your training and experience, there's really no way of telling this jury in any shape or form how a DNA was left behind on an item.
That's correct.
Okay. So if my DNA is on a cap, a T-shirt, or a gun, you cannot tell this jury that I specifically held that item or touched that item to any reasonable degree of scientific certainty.
But then you would have to give me a plausible explanation for how your DNA profile got there at all if you've never handled.
You're familiar with that?
I'm definitely familiar with that. However, the likelihood of me detecting someone's DNA profile via a secondary transfer, in my opinion, is very unlikely.
But it is possible.
It is possible, yes.
All right. So an example, if I shake your hand, or if I give you this pen, the pen that I've been holding with my sweaty palms, I give it to you, correct? You hold the pen.
Yes,
You leave the pen behind, correct?
correct.
There's a chance that your DNA would be on this pen as well.
I would expect to detect a mixture of
Fair
both
enough.
of us.
Okay, fair enough.
Yes.
And if I gave you this pen, and hypothetically you went and committed a crime and left this pen behind, my DNA is still going to be on that pen.
Absolutely, because you came into contact with it.
All right. Doesn't mean that I committed the crime
No, it only means that you came into contact with that item.
with that same item.
That's correct.
All right. In terms of the secondary transfer, again, secondary transfer can be from, for example, person to person, meaning, again, if I shake your hand, that's one example of a secondary transfer.
Yes, it can be.
And then person to object, meaning the example I gave of the pen. If I give you this pen and my DNA is on there and then you handle it, your DNA, the mixture of our DNA would be on that pen.
Right, but that is not a secondary transfer.
No, I understand that, but I'm just
I
saying.
just want to clarify that that's not a secondary transfer. The pen is not him. A secondary transfer would be me shaking his hand and me leaving his DNA by putting my hand down.
All right.
That's a secondary transfer, just so we're crystal clear on
Okay.
that one.
And going again to some of the items where you did find DNA of some of these individuals, again, you cannot tell this jury when that DNA was left behind on that item.
No, I cannot.
And you cannot tell this jury who may have touched that item either first or last.
No, I cannot.
And DNA can be left behind on a particular piece of evidence. Could be hours and sometimes even days. Is that fair to say?
It's possible.
All right. And it's also impossible for you to tell this jury how long or for how long an item was held.
That's correct.
Correct? Okay. And isn't it true that the last person who may have handled a particular item doesn't necessarily mean that they were the major contributor of that DNA or that item?
That's also correct.
All right. Now, I'm going to ask you a few more questions, but just so the jury is clear, in some of these items, you found a mixture of DNA anywhere from 1 to 3 contributors, correct?
Yeah, I think one.
Okay. You were not given the buccal swabs for a person by the name of Jennifer Sharon. Isn't that true?
That's correct.
All right. And this case has been going on for 3 years, and during those 3 years, no one's ever followed up with you and said, hey, here's the buccal swab for a Jennifer Sharon, can you test it?
No.
All right. the victim in this case, Mr. Shannon Griffith, you never were given his DNA or a buccal swab?
Yes, I was.
You were, at what point were you?
I was given a blood tube in which I prepared a stain card.
Okay.
That's how on the shirt, on the, I think it's, where is it? Number 7A, he was excluded from the mixture of at least 4 individuals from that front center of that shirt.
All right, 7A.
Correct.
Did you take his blood or his DNA and compare it to some of Exhibit 5, 6, 2A, 2B, or the other ones that you mentioned or that you just testified?
No, I did not.
All right, why is that?
Because this shirt was represented to me as, my goal for this shirt was to find out, is there any victim blood on it and who was possibly wearing it?
Right.
So the first thing I did was look for possible blood stains, and when areas tested positive, I took those on for DNA in the attempt to tie that item back to the victim,
Okay.
if possible.
Now, specifically in terms of your testing, in your report, did you identify an error, I think specifically as to, I think it's Exhibit 7, does that ring a bell? You found an error in perhaps in the analysis of the statistical determination?
You mean the reason the amended report was issued? Is that what you're?
Correct.
Yes.
All right.
When I was putting the condom wrapper, item 12, was submitted sometime later after the bulk of the item. And when I was putting everything back together, I realized that the statistics performed on 7A, I had inadvertently typed in one location versus another. And so when I realized that, I immediately corrected the issue and issued an amended report. So the report that I've been testifying from today is in fact that amended report.
All right. But you were not asked on direct examination of this error until I just now brought it up, correct?
No, I was not.
All right. But there was an error, and was that an error a mistake that you had made or someone else had made?
I did.
All right. And you caught the mistake, and how long was it before you caught the mistake and submitted the amended report?
The original report date was January of 2010, and the amended report was November 2011.
Okay, so almost 2 years before the mistake was identified.
That's correct.
All right. And was that brought to your attention by someone at the state attorney's office, or was this just an internal audit?
It was an internal
Okay.
finding.
All right. I used the word audit, I apologize. All right. So mistakes can happen.
Yes, they can.
And then you mentioned contamination, and if you could, contamination, for example, would be within the lab, because you testified earlier that within your lab, you prevent any contamination, or you take efforts.
We attempt to the best we can, yes.
Okay, the best that you can, meaning you don't want anything that would contaminate literally or influence the results of your examination. Like dirt, you mentioned bleach is used to clean an area.
When I'm talking about contamination, I'm talking about a DNA type or a DNA profile. I'm not talking about any kind of outside contaminant like bleach or dirt, because those two things are not considered to be a contaminant
Fair enough.
in the laboratory.
But you did mention, though, that you use gloves and perhaps masks in the lab?
Absolutely.
All right. You were not present when these items were recovered at the crime scene?
No, I was not.
All right, so you have no knowledge if they used gloves or masks or anything to prevent contamination when these items were recovered?
It would only be an assumption on my part.
All right. Now, we testified, or you testified a second ago, that you cannot determine when an item or a DNA would have been left behind in an item. And that still stands, correct, obviously?
Yes, that's
All right.
true.
Or you cannot tell the jury held, correct?
Still true.
All right. And then if you could explain to this jury, you're about to say or explain secondary transfer. Explain to the jury how a secondary transfer can occur with more specific detail, if you could.
Judge, I'm going to object to ask and answer.
Sustained.
That you were aware that or were you aware that there was a person, perhaps a fourth individual by the name of Jennifer Sharon? Was that ever brought to your attention?
No, sir.
Okay. Have you ever heard of that name prior to today's testimony?
I don't believe so.
You said there was one item that may have had a mixture of up to four contributors.
That's correct.
What item was that?
It was the stain from the center lower area of the front of the red T-shirt.
Okay.
7A is my item number.
All right, 7A. And on that one, I think you said the analysis identified major contributors, Mr. Rayford.
That's correct.
All right. And the other three you could not identify.
The source of the buckle swab from Jennifer Me and buckle swab from Lamont Newton could not be excluded as possible contributors to that mixture.
All right. And you use that term could not be excluded, but in layman's terms or in terms that a jury can understand or appreciate, there's no evidence to support that Jennifer Me ever possessed that shirt.
Her DNA types are represented in that mixture.
Okay.
And therefore, that's why the term, if her DNA types were not in that mixture, for example, like Mr. Griffin's DNA types, the phrase would have said she was excluded.
Okay. But in this case, again, you cannot determine with any reasonable degree of certainty, scientific certainty, that she possessed, held, or touched that T-shirt.
That's correct.
All right. Touch DNA.
Yes, sir.
I don't know, I can't recall if you actually described that during your direct examination. Touch DNA is, in layman's terms, when you simply leave behind DNA by touching an item. Is that correct?
That's correct.
All right. And again, in terms of the amount of DNA that can be left behind, as we mentioned, just to reiterate, can be determined or can be contributed, for example, if a person sweats a lot or their lack of hygiene. We discussed that, correct?
Those are a few of the factors, yes.
All right. And just because someone is a major contributor as opposed to a minor contributor, again, it doesn't necessarily mean that they were the last person, the major contributor was the last person to hold an item.
That's correct.
All right. And in fact, isn't it possible that a minor contributor could have been the person who secondarily transferred the major contributor's DNA?
I'm sorry, say that again?
The minor contributor, for example, let's say the pen. If the pen has the DNA of a minor contributor, someone that you determine to be a minor contributor of DNA,
Okay.
isn't it possible that the person who left behind the minor contributor of DNA could have been the carrier of the major DNA that was found?
In my opinion, for that to occur, it would have to have been a body fluid.
Right.
Saliva, semen, blood. Just based on my own experience, for somebody to be a minor contributor and secondarily transfer the major contributor, the most likely scenario would have to be a body fluid,
Okay.
not touch.
Right. But it could happen.
It could, but I've never known that to happen.
Well, how long, I'm sorry, and you testified how many times usually?
I stopped counting at 100.
All right. And how long have you been with FDLE?
Well, I was with FDLE for a little over 11 years.
Okay. And who are you with now? I'm sorry?
Pinellas County Forensic
All right.
Laboratory.
And in terms of your education, just briefly again, what was your education?
I have a bachelor's degree from Florida State University with emphasis in molecular and cellular biology and graduate coursework from the University of South Florida in biostatistics and biochemistry.
All right. And in terms of publications, any publications that you may have issued or published or written yourself?
I have been involved on works that have been published, but my name was never, it was only in the acknowledgement, not up in all those names at the top.
All right. You know, if I could have a moment, confer
Yes,
with
sir.
full counsel, thank you. Ma'am, just, I think, one last question. I don't have the background that you do in the degree that you have, so bear with me. When you tell this jury that Ms. Mee cannot be excluded, are you telling this jury with any degree of scientific certainty that she specifically touched an item?
No, all that's saying is that her DNA types are represented in that mixture.
Okay.
How those DNA types got into that mixture, I cannot determine.
All right, thank you. Nothing further.
Ms. Olney?
Just briefly, Judge. First, you were asked about contamination. Did you note that there was any kind of contamination on the items that you tested?
There was
Your Honor,
no-
I object. That would be impossible, I would think. Not within.
Would you say the question again?
I'll try.
Okay.
In your testing, I think defense counsel asked you about contamination of items items of evidence that you might review. In your testing of these items, did you find any evidence of contamination?
I'll overrule the objection. You can answer the question if you can.
There was no laboratory introduced contamination. That's about all I can testify to, is that it was searched and there was no contamination introduced by the laboratory.
And let's talk a little bit about the error and the amended report that you did. This was not an error that you found in your testing.
No, not at all. It was only in the statistical weight that was provided for that sample.
And was the error a typo, like a typo error?
It's very similar to a typographical error when you put in all of the information at all those different locations. All the different locations have a number, a letter and a number. So example, I put the results in at D16 instead of D21. Well, that's going to change the statistics. Not significantly, however, it is going to change the statistics. So when I realized that I had put the information in the wrong location, what I did is I simply took the wrong information out of that location, put it in the new location, recalculated them, and issued the amended report to the submitting agency so that they, and then ultimately you would have the opportunity to see the statistical weight that's given to that statement that I made.
And did you review all the statistical weights in the items that you examined?
Yes, I did.
And all the items that you've testified to today, are they correct?
Yes, they are.
Thank you.
Is she excused or does she remain on standby?
She is excused.
No objection, Your Honor.
Okay, thank you, ma'am. You're free to go.
Thank you.
All right, ladies and gentlemen, we're going to take a 15-minute break. It's 5 minutes of 11, so we'll have you back at 11:10. That should give you time. If you want to go downstairs quickly, you may, but you certainly don't have to. Leave your pads and pens. Don't discuss the case among yourselves or with anyone else. Thank you.
Doesn't matter to me, I was just wondering, some movement over here.
No.
The jurors have the hearing.
Thank you, ma'am.
You're welcome.